This is Prashant Pinamneni, Secretary for NATS Board of Directors 2020 to 2021. On behalf of NATS, I want to thank everyone for participating H-1B wage raise and DHS interim final rule. I would like to welcome Banu Babu Ilindra Garu, attorney at law from BPO. Along with me today, Prasad Arikatla, NATS Tampa Bay Chapter Coordinator, will be moderating this evening. And a quick thing about NATS is a non-profit organization for Telugus in USA. Primary objective of NATS is service. We address needs and concerns that affect daily lives of Telugu people. We do provide social, financial, education support for the community. If you come across anyone who needs help, please have them reach out to helpline@natsworld.org or 1-888-4-Telugu. I would like to acknowledge NATS members Srinivas Malladi Garu, Rajesh Kandru Garu, Sudhir Mikkalneni, Vamsi Venigalla, Murli Mechcherla Garu, Shiva Taluri Garu, Ranjit Chaganti Garu, Prasad Arikatla Garu, Ravi Gumatpudi Garu, and NRI Streams for helping us organizing this webinar. And thanks to our leadership team, NATS Chairman Sridhar Apsan Garu, NATS President Vijay Shekhar Anne Garu, and immediate past Chairman Srinivas Buttikonda Garu. With no further ado, I would like to hand over this to Prasad Arikatla Garu to introduce our man of the hour, Banu Babu Ilindra Garu, and start this webinar.
Thank you, Prashant Garu. Thank you for giving the opportunity for me to introduce our beloved attorney, Mr. Banu Babu Ilindra Garu, who is an expert in immigration and non-immigration and have been taking care of all the needs of the community, whether it is commercial or humanitarian grounds. Banu Garu has always been helpful and trying to help and reach the communities as needed to advise and guide on the latest rules and changes that ever been changing. So with that, I'd like to request Mr. Banu Babu Garu to take over from here and explain our member community and how to handle this latest wage increase and DHS interim final rule and how it's going to impact their future career and also related aspects of the rules changes. Banu Garu, can you please take over from here?
Me? Yeah. Thank you. Thank you, Prasad Garu. Thank you very much for your kind words. And thank you, Prashant Garu. Thank everybody in NATS giving me this opportunity for me to discuss about latest issues, actually the impact of wage increases by the Department of Labor by the interim final rule, and also the regulation changes that have been actually came into effect that have been also passed through interim final rule by DHS on how to define specialty occupation for the purposes of H-1B petition, and also the definition changes which they have made to the employer-employee relationship, and also definitions about the work site, difference between the work site and the third-party work site, and other issues which we generally face, especially our community, our Indian community, with IT consulting business and healthcare consulting business, and also many people who are basically dependent upon H-1B visa program. Thanks for making this. This is a timely seminar. It's a wonderful service by NATS, and it's important to everybody understand the nuances, basically how it's going to impact our society and what are the best possible ways for us to handle our cases, basically depending upon what actually said about this wage levels and everything and all those things. I know that already several seminars have been conducted on this issue, basically, and several pundits and lawyers actually discussed all these issues, basically how the wage calculations happened by the Department of Labor in the past, how it's going to impact right now, and all those things. I do not know whether I have to go too technical about the wage levels in this call, because if I go technically, I think it is too confusing for the people. But still, I would like to talk a little bit brief introduction about how the wage levels are determined by the Department of Labor for each and every position, basically, and how we can do it, and what to be done, and basically how it is impacting us, each and every one, in real time, basically. In real time, what Department of Labor did is basically is that they've actually increased by 128%, actually 28% above the actual prevailing wages right now at the each level for any position for which an H-1B employee sought to be employed. For example, if you're actually paying $95,000 per year for an employee in a H-1B as a H-1B employee in a federal position in Tampa, that wages have been increased to 128% of 95,000 basically. That's what they have done. That is the reality. They have done that for each and every level, for level 1, level 2, level 3, and level 4. We all know that Department of Labor actually prescribed 4 levels for each position to determine wages for the employees, basically. There is a reason why Department of Labor actually prescribed 4 levels for the purpose of determining wages to the employees which employees are intending to hire in a particular pro-offered specialty occupation, basically. And in past, those wages, how the levels have been defined is basically is that the 2 levels, the level 1, level 2, are actually prescribed below mean average salaries of the total number of workers who are working in the same or similar occupation in a particular metropolitan statistical area. And based upon that wages, basically, they have taken the mean average and they put 2 levels below the mean average, that is level 1 and level 2, based upon the educational requirements, based upon the experience requirements, based upon the vocational and other training requirements. Those wages are determined for the particular position offered. And remaining 2 levels, which is level 3 and level 4, have been prescribed above the mean average salary. That means people who are being employed in level 3, level 4 are actually getting paid more than the mean average salary before, basically. And that has been gone up quite a lot. But now what Department of Labor did is basically is that they have increased at the each level 28% of basically wages. Basically, what they have done is basically is they basically made sure that except level 1, level 2, level 3, level 4, if you want to hire an H-1B worker, it will be above the mean average salary that is actually offered to the US workers who are actually same or similar positions in the same located in the same metropolitan statistical area, basically. Okay, that's what they have done right now. And because of that, you're going to see the increase in salaries more than 28%, on average 28% for each and every position, basically, at the each and every level, basically. And they were basically, and also the prevailing wages levels, the level 1, level 2, level 3, level 4 were prescribed in the past in such a way at the lowest bottom of the prescribed numbers, basically for level 1, they have basically taken the statistic level of 17% at that time before October 8, 2020, and then level 2 after that around 42 percentile, and level 3 at 65, 62, and level 4 at 78 percentile, basically. Now, what they have done is basically is that they actually increased to quite a lot, basically, and they basically made it to 42nd percentile, 62 percentile, and 78 percentile, and 95th percentile right now. So, because of that, you will see tremendous increases in salaries and each and everything. And realistically, whether employers will be able to afford these salaries is really a question mark right now, because these salaries are applicable across the board, just not one particular individual or anything like that. Basically, it is for everybody, and basically the reality is it becomes almost impossible for the companies to hire anybody on H-1B worker visa, especially if these companies are located in the metropolitan statistical area like San Francisco, Seattle, or other places, basically. The problem with the wages here is sometimes it's obnoxious the way Department of Labor prescribe these wages in certain metropolitan statistical areas. For example, if somebody wants to hire a software developer entry-level position in San Francisco area on H-1B visa, they have to pay at a minimum $208,000 per year, as per the Department of Labor. You know, I'm not sure any Fortune 500 company will be willing to pay $208,000 per year for any H-1B worker. You know, it does not make any sense basically how it's going to increase the hiring of an US worker, basically because the regulation says that H-1B workers must be paid equal wages as much as they're paying to the US workers in the company who are basically situated in the same or similar occupation. Basically, that means who are basically hired for the with the similar qualifications and the position requirements are same or similar or anything like that. So those are the things which are very, very problematic with the new increase with this wages with the Department of Labor interim final rule, basically. And these wages came into effect from October 8, 2020. So automatically now, anybody who wants to hire somebody on H-1B visa from October 8, 2020, they have to follow the new wage levels prescribed by the Department of Labor if they're using Department of Labor's wage survey, which is basically called Occupational Employment Statistical Survey, which is basically OES survey, basically. Okay, and if you're going to use the OES survey, yeah.
How is that impacting the amendments and extensions and transfers? The wage fee?
Yes, sir. If you
go ahead.
Your question, sir. I didn't get your question, sir, completely. Can you repeat the question?
How is this wages impacting the H-1B transfers, amendments, and extensions?
Yeah, it is going to impact severely, basically, because if you file an amendment or if you file a transfer or an extension after October 8, 2020, employers are obligated to pay the wages as per the new levels set by the Department of Labor, basically. And most of the positions, usually employers hire H-1B workers are in level 2 or level 3 positions, and some are in level 1 positions as well. You know, so salaries are severely impacted at the level 2 and level 3, even level 1 also, basically. You know, and now in many metropolitan statistical areas, as I said, the salaries have been increased by 128% for many occupations, basically. The minimum is 128%. Some of them are even more than that at each and every level, basically. So, if you file an LCA, labor condition application, which is a prerequisite for filing an H-1B petition, on or after October 8, 2020, then you're obligated to pay the wages prescribed by the Department of Labor that came into effect on October 8, 2020. That means the Tampa, I think, had around $90,000 level 2, $95,000 level 2 for software developer position, basically. Now that will be around $114,000 to $117,000, or even a little bit more, I believe. I don't remember the exact number, but that is the average figure you can see across all metropolitan statistical areas, basically. You know, and the same thing with Virginia. Virginia, especially Washington D.C. metro, where we are located, our law firm is located, basically. You know, the level 1 wages were around, level 2 wages were around for software developer was 95,000 until October 8, 2020. Now, level 1 wages itself became $114,000 in Washington D.C. metro area. So if somebody wants to hire as a software developer in Washington metropolitan area, the level 1 wages are $114,000. So level 2 are now as equivalent as level 4 wages, which would be around $135,000 to $140,000 per year in Virginia area, in Washington D.C. metro area. That's basically going to impact several people hirings. I'm actually expecting and worried that many companies basically who are basically employed H-1B workers will let them go because of this, because they can't afford salaries. And the second impact which I'm expecting from this is basically is that many jobs will be shipped out of overseas, basically, you know, because they can't afford paying their kind of salaries to the H-1B workers, and they can't find a talent in the country, because if the talent is there, obviously companies will hire US workers. H-1B workers actually fill in a minimal percentage in IT worker, IT industry, basically. As per the Department of Homeland Security and for the White House, there are only 535,000 people are there on H-1B visa program in the United States as of today, from all the years. The total jobs for the IT industry, people work in several IT positions. I'm just talking about IT industry only, because the reason why I'm talking about IT industry is H-1B program used across all the industries. But why I'm taking IT industry as an example is because, as per the statistics provided by the Department of Labor and the Department of Homeland Security in this interim final rule, last 2 years, basically, the H-1B visa program was maximum utilized by the IT industry. Up to 59% of the visas were actually utilized by the IT industry, H-1B visas. That's why I'm using IT industry as an example when I'm talking over here, because it gives a very broad and understanding basically how it's going to, how it is actually, whether it's impacting or it's basically just the political issue why these visas have been increased. Actually, there's a reality is there any reality or realistic reasons why the Department of Homeland Security and the Department of Labor actually went on increasing the salaries and tightening this definition of specialty occupation and employer-employee relationship, or basically is it pure for political reasons? Basically, that is the whole question is coming over here. And so what I'm trying to say is, because of that, the total IT jobs in this country, basically specialized IT jobs, basically around 26 million jobs in this country. In them, only 535,000 people are on H-1B visa program. That means it's not even 2%, 2.4% people are basically who are working on H-1B visa in the IT industry. And also unemployment in the IT industry is the lowest at all times right now. It's not like H-1B workers actually usurping the IT jobs and from the US workers or anything like that. Of course, in every system and every aspect, there will be some few bad players and there will be some few bad incidents happening. Like, for example, how things happen in Walt Disney or things happen with Tennessee Valley Authority. Those things do happen. It happens everywhere. Everywhere there will be few bad players. But it does not mean that entire system is bad or entire system is corrupted or anything like that, basically. Same thing, if there is a possibility of taking advantage of a law, people will take advantage of that. For example, our president himself said in the last debate that he will take advantage of tax laws and he doesn't feel bad paying $750 in taxes because legally that is absolutely correct. So same thing with what happened with the Disney or with the Tennessee Valley Authority is, but with them, actually what happened is they did not replace those job workers with H-1B visas. They actually shipped them out overseas, those jobs. And they're not talking about shipping the jobs overseas. They're talking about bringing 1 or 2 people, H-1B workers, and shipping out 150 jobs, 250 jobs overseas. They're not talking about that. If you bring in those H-1B workers to perform those jobs, then obviously all these H-1B, all the US workers are also going to stay here in this country. Those jobs are not going to overship to some other country where that country is actually getting benefited with this kind of a policies, basically. So that is one impact which I see is basically is that many jobs can be impacted, overshipped, shipped out, basically. Many companies may not be able to afford the salaries. I don't know which company in Bay Area will be giving entry-level H-1B software engineer $208,000 per year. That is not realistic, basically. I mean, that's my expectations, basically. So I'm sure. Yeah.
Can you take a logical break here and do you mind if I quickly reiterate a couple of things what you have said? So thank you for wonderfully explaining us about the someone on mute. They can put some, yeah. Thank you very much for explaining us about the wage level challenges what we will be having due to the new DHS law. I think the takeaway messages are the wage levels have been increased based on the MSA, either 28% or in some cases 128%. The impact you have been stressing again and again on the impact of this is massive layoffs of H-1B employees. Second thing is a lot of this work will be outsourced. So this is the impact what you have been telling us. I would like to ask if we can go through a couple of questions, what they're asking, and then we can continue on this one. First question is the wage increase. Is it impacting only H-1B workers, or is it also applicable for anyone who is working through green card EAD?
It is only impacting H-1B workers and also the people to whom companies are planning to file green cards in the future. That means if the company intends to hire somebody who's an H-1B visa or an L-1 visa in this country, or an O-1 visa, P visa, any work visa in this country, and if they like to sponsor green card for them, those wages are going to be affected. Basically. But people who are working in EAD, those people wages are not being affected, basically. But only the wages going to be affected is the people who also file H-1B visas and E3 visas, specifically. They also will be impacted because of this. And along with E3s, H-1Bs, and also people who wants to be sponsored green card in this country after October 8, 2020. And also, I'm going to explain a little bit more ones who are actually going to be impacted. And basically, is there any way for us to deal with this issue in practicality, in reality, also with the wages? How we can basically sustain our business along with the dealing with these wages also is something which I would like to discuss, Cindy. And I would like to go with that also right now. I think we're getting some background noise. If anybody that can be muted, will be. Thank you. Thank you very much for that. And so that is very, very important for us. Yes, I know wages have been increased a lot, and we are seeing what's the impact it's going to be, how it's going to affect the industry, how it's going to affect all layers of industry which basically use H-1B program basically to hire foreign workers when they can't file actual talent pool in the US, basically. And the basic thing is basically is that how we can get away with it, right? Basically, yes, I mean, there are several ways which we can do. Department of Labor actually did prescribe who are going to impact, who are not going to impact, and everything. If somebody has an extension to be filed or amendment to be filed basically within the next 6 months, and if their LCA is already filed prior to October 8, 2020, then they're not required to comply with the new regulations, new wages basically, because the LCA has been filed prior to October 8, 2020. And also, if anybody's H-1B is already pending in an extension or pending amendment or pending transfer or pending change of status, they're not being impacted also. Basically, they are basically governed by the old regulations with the Department of Labor wages. So their case will be adjudicated accordingly only. Same thing with somebody who's trying to get filed their PERM ETA 9089 labor certification to get their green card basically. If the Department of Labor already prescribed the prevailing wages for them prior to October 8, 2020, then those wages are still valid. Those wages are valid till next year, June 30, 2020. So employers can able to continue their recruitment process and able to file ETA 9089 for those employees, and the I-140 and 485 if the dates become current for them to file their adjustment of status application in this country and everything. They can actually do that also basically. So only the people who will be affected with the green card is basically if the prevailing wages are going to be certified on or after October 8, 2020. So that is where the whole thing comes in basically, So those are the people who are going to be impacted. Second thing is basically is a lot of employees ask me, sir, is it any way we can legally pay a little bit lesser than what the Department of Labor is saying, because market-wise it's impossible for us to get any business on that rates. No clients are going to pay us that kind of a money, so we will not be able to actually sustain our business in that way. Department of Labor did say in the regulation saying that they do accept alternative wage service basically. Okay. Alternative wage surveys are actually private surveys conducted by several agencies and organizations in accordance with the regulations complaints of the Department of Labor. That means they have to meet the Department of Labor regulatory standards in order their wages, alternative wages, to be valid basically. We use these alternative wages all the time in our firm, especially if the people are working in San Francisco Bay Area or a Seattle, Washington area, where salaries are generally, Department of Labor wages are very high in those metropolitan statistical areas. we always use alternative wage surveys there. And most very famous alternative wage survey which we use is Watson Towers, basically. It's called Watson VAT also in the past. Now it's Watson Towers, basically. Their survey is very well accepted by the Department of Labor. So we use those alternative wage surveys, which basically they usually provide the mean average salary to be paid to an employee in a specialty occupation in a metropolitan statistical area where the employee is going to work. Basically, they're going to provide also how their survey actually taken, what are the standards they actually followed, and how those standards meet the requirements or the regulatory standards set by the Department of Labor in order to accept them as a valid pro-offered wages or valid prevailing wages for the employees, basically. Okay, and that could be one option which they can look into, basically, because usually these alternative wage surveys will give around $10,000 to $20,000 difference for each position at the level in which you are planning to hire individuals, basically. And also these wages in alternative wages usually prescribed in 5 levels, basically, in some at 6 levels, basically. So it's P1, P2, P3, P4, P5, P6, depending upon the education, experience, and vocational requirements of the position. Basically, you can actually decide which level you want to decide to pay the wages to the employee, and accordingly, you can actually decide the wages for that employee in that particular metropolitan statistical area. Of course, it's expensive. Alternative wage surveys are expensive, but still, that is you're not spending $20,000, $30,000 in addition to the salaries which you're paying to the employees. You may be spending $400, $500 in getting an alternative wage survey for the employees. So that is one.
For the wonderful suggestion and takeaway messages. We see some light at the end of the tunnel to try through the alternative surveys.
Yes.
Also, from a timing point of view, we reached almost 30 minutes. Do you mind if I request you to change gears and also talk about the other impact areas like specialty occupations or duration of H-1Bs?
Definitely, sir. Definitely, sir. Thank you, Prashantkar, for bringing that up right now. And then we'll go with the other areas also, basically. Now we will talk about the interim final rule passed by the Department of Homeland Security on the same day the Department of Labor interim final rule came into effect. That is on October 8th, 2020. And they said that those regulations will come into effect from December 7, 2020. The major thing which everybody has to understand in this basically is that if any employee works at the third-party client site, basically, any H-1B employee works at the third-party client site, that H-1B cannot be approved more than in a year, basically. That is major impact in the industry. Usually H-1B is approved for 3 years at a time, but if the employee works at the third-party work site, then they're going to approve it only for 1 year, not for 3 years. Okay, that means that is going to actually increase threefolds the expenses for the company to sponsor and continuing sponsoring H-1B visas for their employees, and they have to plan their business accordingly. That is a major takeaway with this particular regulation that is going to come effect from December 7, 2020. So any cases that have been filed right now that have been pending, and if they are adjudicated before December 7, 2020, you're going to get 3 years. But after that, you're going to get only 1 year. Because once those regulations come into effect, they're going to approve it only for 1 year if the employee works at the third-party work site. And the second part, major important thing is basically is that Department of Labor made definition changes to what is meant by specialty occupation as per the USCIS regulations, basically. Right? I mean, we know that specialty occupation defined in the statute is that the position that requires at a minimum bachelor's degree or its equivalent in a specific specialty for the pro-offered position which employee is intended to be hired for, basically, on H-1B visa. And for that, USC has actually prescribed through its regulations 4 prongs and said that if you meet any one of those prongs, basically any one of those 4-prong criteria, then you may qualify or able to prove under the preponderance of the evidence standard that your position qualifies as a specialty occupation. However, prior to the recent decision given by the Washington, D.C. court, and also settlement happened between the IT Serve Alliance and the USCIS, we have seen tremendous denials in H-1B visa on a specialty occupation, definite position, basically. They basically try to impose the standard, what actually stated in the regulations right now, prior, without any passing of such interim final rule, through the Neufeld memo, as well as the unnamed interim memo that has came into effect from January 2018, basically. Both those memos have been stricken off because the courts held that they did not pass the muster of APA, and also actually they deal with substantial changes in the law, therefore they cannot be valid, therefore they basically striken off those two memos and basically gave a decision against USCIS. That's why we started seeing approvals for the past 6 months from April onwards, 3 years approvals without any problem. And also there was no requirement for us to provide anytime contracts or agreements or letters also in full to get the approval, especially when the employee works at the third-party client side. Now, USCIS came back and said in the specialty occupation is basically is that you have to, it's just showing one criteria may not be enough. You may have to prove other factors also, other 4 criteria, other 3 factors also in the 4 criteria to show that the position qualifies as a specialty occupation or not. If you don't, it's you may risk a chance of getting denial. And also they change certain definition language changes basically in the regulations, basically saying that it is very important for them to make those changes in language changes, basically those phrases which have been written in the past in a very different way, basically because they have to bring it definition, they have to interpret the definitions before of the specialty occupation definition as close as to the what Congress intended while passing the Immigration Law Act in 1990, basically. INA, Immigration Nationality Act in 1990, basically. Okay. So they said that now they are very much in compliance or very much in adherence with the deference authority given to them, or deference or discretion authority given to them, that they're defining the specialty occupation as close as to the what Congress intended. That's what the comments section stated in the interim final rule, what they have given actually, basically. Are you able to hear you? Basically, I was getting a message saying that my microphone is noisy. Are you all able to hear properly?
No, we are able to hear you loud and clear. I think good.
Okay, thank you, Prashant Garu. Yeah. So, so that's what it is basically, right? So now, and also basically they define what is bachelor's degree or its equivalent in a specific specialty, right? They actually stretch on that. What they're saying is that the field of endeavor or the major of the degree in which you are actually hiring an individual must be directly related to the specialty occupation. It cannot be vague or it cannot be multiple degrees. If you, for example, what they're saying is basically is that if, as per the Department of Labor Occupation Outlook Handbook, the software developer position requires at a minimum a bachelor's degree or its equivalent, which is basically US bachelor's degree or its equivalent. That's what they meant when they say bachelor's degree or its equivalent in a computer science or related fields, basically. So what they're saying is that the direct field of endeavor for software developer position is computer science, or any degrees that are related to the computer science are acceptable as direct degrees directly related to the specific specialty occupation, that is basically computer software developer position, basically. But if you have a general engineering degree, and if you say that is also a requirement which you're going to accept somebody to be employed in a software developer position, then they say that the position may not qualify as a specialty occupation because general engineering degree is not a direct degree, basically. Okay, they want you to provide a nexus or a connection between the general engineering degree and the computer science degree, or for the position which employer is actually going to hire an employee. That means if the employer is hiring somebody as a software developer position, basically, if they say that they hire somebody with a bachelor's degree or equivalent in computer science, engineering, or related field, then they say that the position may not qualify as a specialty occupation because engineering means there are several departments in them, several variations in them, basically how such a training is required for somebody to work as a software developer position in their company. That's why they say that those are the positions where they may deny the H-1B petition, or basically they may issue an RFE on them, basically. And at the RFE stage, we will be given an opportunity to explain how engineering degree is directly related to the specific field of endeavor, specific position for which we are hiring an individual, basically. So basically, we would say the specific occupation rather than a position here, and the specific occupation for which the employee is being hired, basically. And that's the thing. This is what actually they did. They did try through with the policy memorandum with the no guidance and everything in the past, and they have denied several cases in California Service Center based upon this particular reasoning. Now they're trying to make that legalized through the regulatory passes, that too not to following notice in common procedures, but through the interim final rule, basically.
Manu garu,
I don't know how it is, this interim final rule. Yes, sir.
Banu garu,
Yes,
is
sir.
there any solution for this, or in the past they have shown the experience even though the degree does not come from a computer science? So similarly, is there any solution you have in mind to, because a lot of people, I'm sure, who are from non-computer science background are already having these H-1Bs and they may be close to doing their extensions or amendments?
Yes, sir. Basically, see, the USA clearly says that, and the regulations do permit you to show that you have an equivalency to computer science or related field through your education, training, and or experience, basically. Okay, and how they did is basically is that if you have a 3 years of progressive responsible experience that is equivalent to 1 year of academic study in a accredited university, basically towards a bachelor's degree in a particular field of endeavor. So if you have a 12 years of experience, you can actually, and those 12 years must be progressive in nature. You know, we all know what is progressive in nature means, right? Progressive means your experience must be growing. It's not like you're doing same thing every day. Like, for example, if your task is basically testing one particular task, basically, or one particular application without doing any other algorithm changes or anything like that, or any other writing up program and everything, then that's going to be a problem for you, because there is nothing you're doing additional task than just doing the one aspect of testing in the program what you're actually working on. So the nature of the experience must be progressive in nature, basically. So, and if you can document that your experience was progressive in nature, and if you can show your numbers of years of experience is or training is equals to that equivalence of education, basically, then you will be okay with it. How do you show that progressive nature experiences? Through your experience letters. You know, that is only the way. You have to get proper experience letters from the companies, and if you don't have if your company doesn't have if your former companies doesn't have a policy of issuing experience letters in detail, try to support that through the affidavits from your managers, from your colleagues who are actually aware or have a first-hand knowledge about your job, what you have done in those companies. You know, that is one way you can show that, and get an education evaluation or expert opinion based upon that, and you can substantiate along with those things also, basically. That is basically a direct, you're basically showing that he has an equivalent education to the computer science, basically. But if you have somebody with engineering degree, doesn't have any experience, basically, and you are going to hire him in the company as a software developer, basically, and your requirement saying that in our company we usually hire somebody with a bachelor's degree or equivalent in computer science, engineering or related field, then how we are going to document that? How we are going to show that engineering degree is a related degree or a directly related degree to the position of software developer in which you are basically hiring? It is possible to show that, basically. Sometimes it's not. Reason because sometimes, even though you're working as a software developer, basically, depending upon your domain knowledge you have, or the fee or the industry in which you are working, the person must have that knowledge in order to execute those job duties, basically. You know, and how, if that knowledge, basically the training which is got in that engineering degree is relevant, that relevant means it should be more than 51% or 55%, basically. Anything above 51% of the job duties are related to the particular engineering degree. Engineering people who have engineering degree can provide or perform those tasks competently, then that position can qualify as a specialty occupation. It's very important to show the nexus or a connection between the job duties and the courses which an individual actually did in the particular field of endeavor. We have done this all the time. We have done this all the time in our practice, basically, and we were able to successfully get approvals in the past. At the same time, we have seen denials also. It's not like we are any exception from anybody else. We have seen some denials, but majority of them are approvals basically. As long as you can show connection or an excess between the job duties for which the position is there, and then basically you basically show the courses of which employee actually has in his undergrad degree or master's degree, if he has a master's degree, which we can equate to undergrad degree basically. And those courses, what has been taught in those courses, if they can write up and everything, that would be great. So here, employers and employees must have an ability to explain how those coursework is related basically to this particular position. If they're not capable of doing that, then it's very difficult for lawyers to support that basically.
If I ask a follow-up question on the same topic. So what
Yes,
if the employee comes from a non-IT background, but they enroll into some online courses like Udemy, or like they go to a community college and they get trained on certain skills? Is that going to be of any help?
it has to be academic education basically. Otherwise, if they're accredited training, as I said, the training is actually treated just like an experience. So if you have a 3 years of academic training, not academic studies basically, right? If you have vocational training of 3 years of vocational training, I would not say academic training, I would say vocational training basically. If you have a 3 years of vocational training, that is equivalent to 1 year of academic study. Okay, so if you get the training from the community college, which is very valid institute to provide the training, and if that vocational training, if he has a 3 years of vocational training for the community college, that can equate to 1 year. But if he has an academic study in community college 3 years, and if those 3 years credits can be transferred to a regular bachelor's degree towards the bachelor's degree, then they'll be considered equivalent to bachelor's education academic study basically. So those are the things which we have to understand basically. Online coursework means if it's a full-time, it does not matter whether it's online or it's in person basically. Okay, as long as it's full-time. Even if it's a part-time also does not matter, as long as the education is from accredited university basically.
Thank you for clarifying.
Yeah, so that is one important aspect which we would like to tell you all basically, because we are going to see after December 7, 2020, rapid increase in the specialty occupation RFAs basically, and also on the right employer-employee relationship as well. It's going to be the same what we have seen in the past, maybe with vengeance right now with the USCIS. Okay, I'm sure AILA is working on filing a lawsuit on this. I think ITSR also, Alliance also is working on to fight a lawsuit, and several other agencies also planning to file a lawsuit on this, because still we strongly believe it is against the law the way they try to approach this issue and try to pass this interim final rule by the USCIS and also with the Department of Labor as well. Second thing is we have to discuss about the employer-employee relationship, right? How it's defined in the past and what now, as per these regulations, what they're trying to achieve with it basically, right? And with the employer-employee relationship, what they're trying to do is basically is this, okay? The regulations state that if an employer who has an authority to hire, fire, pay, supervise, or otherwise control the work of the beneficiary, then they can easily establish employer-employee relationship. Even the courts basically define that particular regulatory definition is that if you can prove any one of those factors, basically, then you are eligible to seek an approval as a valid employer. You establish valid employer-employee relationship, basically. You do not have to prove all those factors, basically. However, USCIS was very adamant from 2009 onwards, where they basically adapted a Fifth Circuit decision, basically, that is basically Defensa versus Meisner case law, that has been decided actually in 2000. That case came in 2000 actually, but that case law was not adapted until 2009 as a precedent by the Department of Homeland Security. But they did in 2009 when Obama government came into power. Okay, and so what he did is basically Obama government did is basically that they basically called it as a precedent, and then basically they said that is if the most important factor to determine whether there exists an employer-employee relationship, especially if the employee works at the third-party client side, is the term control, basically. That is a common law definition. How do you prove in a common law whether employer-employee relationship exists is basically is how an employer controls the work of the employee, basically. Whether he exerts any control on the day-to-day job duties of an employee, basically. Okay? And that's how the common law definition is defined, how employer-employee relationship is. Many states have not adapted codified statutes, basically, under the employment law, how to define employer-employee relationship is, basically. Many states, even still date, there are a lot of states, even till date, the states follow in equity or in court, basically, the common law definition of employer-employee relationship, basically. So the defense versus Meisner actually said that only. When the employee works in the third-party client side, we cannot know how an employer actually controls the work of the beneficiary, basically, because if he can show that they actually directly control the work of the beneficiary, then they can qualify as an employer. And accordingly, they ruled in favor of the Department of Homeland Security. Actually, at the time, it was INS, not the Department of Homeland Security in 2000, basically. They ruled it in the favor of INS and denied the case for the plaintiffs in that, basically. And the plaintiffs were actually nurses, company, which actually places nurses at the third-party client, so that is at the hospitals, basically. Okay, so that case law is actually now, they reiterated that case law in the regulations everywhere. Wherever reasoning they have said in the regulations, they basically put the footprints, that case law, the analysis of the case law, the reasoning behind the case law, the dictum, arbiter, everything basically in that particular case law in the regulatory changes, basically. So what they basically said right now is, these all terms, hire, fire, pay, supervise, otherwise control, individually they don't make any difference, basically. They all together, basically. Therefore, they're only going to consider control in the definition, basically. So they're going to make a regulatory change to the definition of the language of the employer-employee relationship. They're going to define that is, if the employee works at the third-party client side, or even in person also, employer must show how he controls the work of the beneficiary on a day-to-day basis. And if they can establish that, then they're eligible to get the approval of the H-1B petition. And the crucial difference here, what they have done is in the regulatory changes, basically, is that they removed the term contractor, basically. And it's very difficult. I mean, it's very difficult for me to in this call to explain the entire definition, how it has been done and everything, because it's beyond the time we have basically right now. And they removed the term contractor and they replaced that with the company in the particular regulatory language, basically, which they have in the regulations, basically. And that's how they're trying to assert, basically saying that if the companies can establish in just control, then they qualify as an employer, and the employee, and if the position meets a special occupation definition, they can get the approval, basically. And this comes basically is especially very crucial if the employee works at the third-party client side. If the business model is that you actually place your employees at the third-party client side and they actually provide services for you at the third-party client side, then this issue will come. And they also basically, so that is one thing which employers has to worry about from December 7, 2020. Now, because of the memorandum issued by the USCIS by revoking or by rescinding Neufeld memo and the unnamed itinerary memo, now we don't have to prove the control. As long as we prove any of the factor, hire, fire, pay, supervise, or otherwise control any one of the factors, we are eligible to get an H-1B approval, basically, as an employer. But from December 7, 2020, it's going to change to the common law definition, which is basically control, and they're going to stick it to you to that particular definition, basically. And
what can I ask? What is the solution? How can, as an employer, protect their employees? Can we get their weekly status report? Should we have daily calls with them, stand-up calls or weekly calls?
Absolutely. Scrum meetings, stand-up calls, stand-ups, basically weekly calls, getting day-to-day updates basically from them. I mean, employee has to do one thing, basically. End of the day, make sure that you have some kind of system in your company and providing updates in them exactly what he has done at the client. And exactly, they provide the description, what is the project about, basically, to you, and exactly what they're doing in their project, how many team members are there, what they're doing, everything, basically. Just create one system, in your application system in your company. Maybe some software. I think there are some third-party softwares, so many of them are available outside. And ensure that your employee provides the updates in the system. Make sure that you basically have this employee counseling at the beginning of the job to them with your handbook material, whatever you have, and ensure that they actually follow those rules and procedures. Basically, tell them not become a little bit more active after the job to spend 10-15 minutes in providing these updates to the employer, basically.
And it should be two-way, right? Not one way.
It has to be two-way. It has to be two-way, basically. But if the point is, if you have a system in the application or system or anything like that, they can automatically update, and that updates automatically will be given to the employer. So employer knows exactly what the employee is doing, and if employer has a technical knowledge, if he has a technical knowledge, if he can help him, maybe he can guide him. Maybe you should have done this application this way, or maybe you should have done this particular particular algorithm this way, or you might have written this code this way. Probably that would have helped the employee to perform competently over there. Is everybody there online? Because I'm seeing, yeah, everybody's there. Yeah, somehow in between I lost the Prashant Garu image. So that's what it is. I mean, it's actually it's both ways, sir. It's employer and employee. It's both ways basically. But I think employees have to be more proactive, providing that information to the employers, because employers can set up a system and then they can just follow the system in the company. Basically, it's not that difficult for the employers. It is about the employees, basically. That is what it is here, basically. And that is how you can deal with it, to show how you control the job and everything. We were basically dealing with this even in the past also, and so it's nothing new. That's what I'm trying to say. But we may see more denials in vengeance, basically, rather than anything else, and obviously more appeals, more lawsuits again on those cases. Basically, that's what is going to happen. But this is what is going to come into effect from December 7, 2020. And other thing which is more important is basically is that they said that they're going to rapidly increase site verifications basically from December 7, 2020. And you can expect each and every case will have a site visit after December 7, 2020, once this thing is there, because you're going to attest to the fact that you're willing for the site visit complaints basically. And if you don't complaints with site visit also, they discuss few things in that. I didn't get a, I mean, it's not, it's basically there always, you basically attest to the fact that you're basically volunteering, you're actually accepting USAs or giving an authority to the USAs anyway while filing H-1B petition to conduct the site visit basically and verify all the facts, what you're selling is true and correct basically. And if you don't do that, they're not going to accept your H-1B petition either way basically at the time of filing. That's why I'm not going to stretch on that. But what I would tell you is employers be aware and be prepared that they can expect more site visits. And if that is going to happen, ensure that your employees are properly understand the process and the procedure for site visits and provide the information properly. That is one thing which you have to understand. And also they've defined the difference between the worksite and the third-party worksite definitions basically, right? So those are the things which is now that definition is very, very crucial for us to get 1 year approval or 3 years approvals basically, right? And also they said that they reserve the right to approve even period less than 1 year in these regulations, just like how they were doing in the past with the 2018 interim memo, right? They can even approve for 1 day also if they want to after December 7, 2020, and those are the problems which we have to see and we have to worry about basically. My issue is basically is that with these two regulations, we have to deal with it. One, we have to see whether we can use alternative wage surveys in the metropolitan statistical area where the employees are working to avoid or deal with the wages and everything. If you can deal with it, then if you especially employee works on third-party client sites, maybe employers need to demand clients more money to pay the wages to the employees. So, but second is probably not possible in business-wise. It doesn't make business sense. But I would advise that they use the alternative wage surveys. I think that is the best solution to deal with this particular issue. If it comes to specialty occupation, employer-employee relationship, I think most of the employers already dealt with that issue for the past 10 years, basically. Therefore, they should be able to handle that issue very, very well. And I think most of the employers still, even they got relaxation from April, I think they're still following the same methods and same processes in filing H-1B petitions and going through the same thing. So I'm not worried too much about the practicality with that. Only thing I'm worried about is how many RFAs we are going to get and how many denials we are going to get with that particular regulation, basically. And one more important thing which I want to tell you is basically is this, okay? the October Visa 2020 bulletin, right? It's not related for our topic today, but I would like to stretch one important point here is now these regulations actually made it even more important. People take advantage of the October 20 visa bulletin, especially the employees who are waiting for a queue for a long period of time. And if their priority dates, if they have a possibility to file their 485s, they should file their 485s. The reason for that is, as I said, is impact on H-1B, how the companies hiring them on H-1B visas can impact a lot in this country. What tomorrow if their companies lay them off because they can't pay the wages, because their extensions comes in due and they can't pay the wages what they're supposed to pay for the candidate, they say that they will let go. That's what happens in full-time employment, right? If the companies can't afford, they'll let you go. So make sure that right now, this has even become more paramount right now, you're filing your 485s and take advantage of the October visa bulletin. I'm hoping you may have the opportunity in November visa bulletin also, but what if you don't have an opportunity in November visa bulletin? Take advantage of the October 20 visa bulletin right now and ensure that you file 485s. Do not worry what's going to happen after 10 years, after 1 year, what's going to happen if EB2 becomes current, or what's going to happen if EB3 becomes current. Those things are nonsense. First, you get into the queue by filing your 485. Those issues can be dealt later on, basically. Don't worry about, okay, if I file EB2 and EB3, my I-140 may get denied EB3. Is it going to impact my EB2? No. If your I-140 is not approvable in the beginning, it's going to impact irrespective, no matter what, whether you file EB3 or not. Okay, so don't have those kind of apprehensions. Basically, it is very, very important now. It's more even paramount for you to get into the queue with the 485, basically, because if you file 485, it allows you to stay in this country, allows you to apply for employment authorization while your 485 is pending with the USCIS. So that allows you to continue to work. So if that happens, then employers need not worry about wage increase by the Department of Labor for you, basically. Okay, so please take advantage of this visa bulletin opportunity because it doesn't come that often. Last time this opportunity came for Indian nationals in 2013, and now again in 2020 after 7 years. So please take advantage of this. Hopefully 2020 it's continued, so November also it continues, and if it continues, we are very, very happy. What if it doesn't continue? So take advantage of this. That's all my humble request to the entire audience in this country who are actually in the process of their green card or anything like that, basically, or who are listening to the session, who are in that process basically right now. I think we covered up everything, sir.
Sure. Thank you, Bhanu Garu. Thank you for explaining all of us. And I think I definitely, as a quick recap, some of the solutions you suggested are to use the alternate wage surveys, work or may not work. And the other solution you said is see if your clients or vendors can increase the bill rate so you can pay your employees accordingly. And the key thing you have stressed is the compliance. Educate your employees as an employer about the upcoming site visits, which almost would be mandatory for every case going forward. And the other takeaway message you also have stressed is don't take advantage of the October 2020 bulletin about applying for your 485.
Go and take, sir. I said go and take. Go and take.
Go and take. Okay. Go and take advantage of this and not worry about ifs and buts.
Yes.
And thank you also for educating us on the wage level increases and the impacts. You might get layoffs, so you always should be more prepared. And some clients might, you also enlightened us with an opportunity here that some of the work will be outsourced, so some of the employers can start taking advantage of it. And you clarified mainly about what is a third party versus the work site. And if you are in a business of placing employees at client locations, then you should be prepared and budget yourself for the extra costs of renewing their H-1Bs after 1 year.
Yes, sir. That's correct.
A couple of people are asking these questions. What is the probability of getting AILA and IT Server trying to fight on this? What do you think is the probability of them winning this case?
It's almost impossible to say that, especially I'm not an APA litigator.
Yeah.
I don't know much about APA. That's why I can't really comment on that. See, the probability is always 50-50. It starts there, you know, and from there, it all depends upon the work the lawyers do. It all depends upon how much they can persuasively file their case and present their arguments to the court. That's what matters a difference a lot, you know. And no, the people who are actually litigating on behalf of ITS or AILA or whoever they are, they're very competent. Would like to go with the litigation. They're not just doing it to get the money. I know that they will do a great job with it, basically. So we need to trust them in the process.
Exactly. Also, I mean, some of the questions I think you have already answered. Some people are asking what will happen to my pending green card prevailing wage, or will I be impacted by if I already have an approved H-1B? But just one final time, they want to hear from the lion's mouth.
Sure, Prashant Garu. The first part is basically is that if the prevailing wages are pending and they're not certified yet, then that's going to be impacted with the new wages, basically. That means they are going to get the prevailing wages certified with the higher wage levels than what it was there in the past, basically. So their employers, they have to be willing to pay those salaries for these individuals once they get the green cards, basically. They do not have to pay in the beginning, but they have to adjust to the fact that they have to pay those. They will pay those wages once upon receiving the green card for that employee. However, that employer has an obligation to show ability to pay for the wages of that employee during the entire duration until they get the green card from the day the labor certification is filed. If the employer is more than 100 employee company, then it's very easy to meet that obligation. If it's less than 100 employee, then they have to document extensively the documents about their business, the totality of the circumstances, how the business is and everything is, and they can document in that way also. So yes, they're going to be impacted. If the prevailing wages are not certified, then they're going to be impacted, basically. If the prevailing wages are certified, then they are not. They're still valid. They will be able to use those and able to file ETN, I-010 accordingly, I-140 accordingly, and everything accordingly, basically. Sir, can you repeat the second question, sir, about the H-1Bs? What was the question?
Sorry, I would like to move on to the next one if it's okay. I mean, it's lost in the chat. Okay. So the next one I have is specific. I'm an Indian-born Australian passport holder with an E3 visa. Mm-hmm. Is the wage raise applicable for E3 visas too?
Yes, it's applicable to E3 visas too. E3 visas is nothing but an alternative to H-1B visa, and it is given only to the Australian nationals, basically. So the compliance requirements are the same as H-1B petition, so the wage levels will be applicable to them as well.
And the other question we have is, can an employee move to L2 from L3 with an old H-1B which is being filed? The question is a little vague. I don't know how to frame it.
From L1 to L3, L1 to L2, or basically what they talk. I don't think there's anything called L3, so I'm confused.
Yeah, that's what it is. But I have one more interesting question. Can a current level 2 file an extension with a level 1 as DOL salary has changed?
It is possible. It is absolutely possible to do that. But however, it cannot be filed as a pure extension, basically. Okay, it has to be filed as an amendment with an extension, basically, because you have to show that there was a material change in the job requirements for which employee is going to work upon expression of this H-1B petition, basically. Because of that, it has to be filed as an amendment with an extension and can be filed in level 1. You have to understand this. USCIS always doesn't like when they're going from higher level to lower level for the same employee, especially when the employee is working in your company for a certain period of years, basically. Okay? You have to have a very strong argument to show that it is totally justified to hire that employee at the lower level position while the extension is pending or while you're filing an extension and everything. Therefore, documentation is very, very important. How material change is that position from level 2 to level 1, and therefore you're basically paying him level 1 wages. You cannot say that market conditions are bad, I can't afford him. No, that's not going to be the argument. Argument is you need to show the requirements of the position. There is a material change in the requirements of the position. So you have to be technically really savvy on how to draft those things and document that basically. And then you can actually file an amendment with an extension. It is absolutely possible. And that's what we are advising all our employers also. You can actually do that, but basically, and then we'll be happy to make a legal argument how level 1 position does qualify as a specialty operation. We don't have any problem with it. We can make legal, because even doesn't matter if it's level 1, level 2, level 3. If it's a specialty operation, it's a specialty operation. But we have to document that how the position actually became a level 1 position instead of level 2 position while you're filing an extension. So you file it as an amendment with an extension, basically.
That also brings up another question. For an MS student as a cap case, can we file for level 1?
Yes, absolutely. You can.
So what will differentiate level 1 versus level 2 for a cap case?
So the level 1 position requires a minimum requirements for the position, does not require any experience or any other qualifications, because level 1 position usually requires somebody to competently perform his bachelor's degree or its equivalent in a specific specialty, basically, right? The whole problem comes is that with the IT positions is by statute, they're not defined as a specialty occupations. However, Department of Homeland Security always taken a stand, that is US has always taken a stand, certain positions are so specialty occupation because inherently those positions requires bachelor's degree or equivalent in a specific specialty, basically. That's how it is. If the employer can define that job duties and state that this position does not require any independent, I mean, they will be always working under the supervision of somebody else, and the position requires only bachelor's degree at a minimum, and the independency nature of the job is not as much as compared with the level 2 position, then they can easily qualify for that position. I don't see any problem filing for bachelor's degree.
Got it. With this new rises, right? So a lot of people are inquiring about the possibility of filing in level 1 wages versus level 2. Mm-hmm. What you would generally advise? I mean, do you expect any careful review or?
I would always like to review the position, sir, basically, before I can comment with what by filing a level 1 or level 2. First thing is that. And second thing is basically is that if you have an alternative wage survey available to you, and if it's possible for you to use an alternative wage survey, use that one, alternative wage survey. Okay. And if you cannot use the alternative wage survey, then review the position carefully. And if that position can be defined as a level 1 position, then we can file it in level 1. Otherwise, then we may have to stick with level 2. If the position requirements are really level 2 position, then we have to,
Got it. So is there any experience level where it differentiates from level 1 to level 2 in general? I know it's we're getting into the particulars.
Absolutely. Because as I said, level 1 is a vocational SVP level requirements is 7 less than 8. Basically, that means you'd require either bachelor's degree or a 2-3 years of experience. Basically, that's what it requires. If you go to level 2, then it requires bachelor's degree plus 2 to 3 years of experience above that, basically. Okay, so or master's degree equivalency, basically, or master's degree at a minimum, basically, for level 2. So that is where the whole things makes a difference, basically. But as an attorney, I never like to prepare master's degree as a minimum requirement for any IT position, specialty operation, because position does not generally require master's degree at all at a minimum. It requires bachelor's degree or its equivalent. That's going to be a slam dunk RFE case if you do that, basically.
One other question. Certain areas, especially certain geographical areas like San Francisco or California, especially, we don't have the wages defined. And what do you suggest if someone needs to do a transfer and amendment at this point of the time?
As I said, because the wages have not been defined, then you have to pay $208,000 per year. That's what the Department of Labor says. And the problem is because the wages have not been defined and it's basically $208,000 per year, I would always advise go with the alternative wage surveys over there. Okay?
Got it. So how effectively the alternative wage survey worked in the past, or is it a famous one, or do you think?
It is a very famous one. We basically, this cap season, we probably would have filed around 300 to 400 cases with alternative wage surveys. Okay, and also regular extensions. Also, every month we file at least 40 to 50 cases with alternative wage surveys.
Perfect. So, can this be considered as one of the alternative for time being because of the?
It is, as I said, it is But it is only thing I see problem is with the employers is alternate wages does come with the cost, right? Because you have to pay to the survey providers for each alternative wage survey, depending upon what survey it is. Some people charge $200, some people charge $250, some people charge $650. Watson Towers, the survey which we use, usually they charge $650 per case per survey. But in our firm, we actually made an arrangement with them. We get for quite a good rate basically for our clients and everything. So basically, clients have to understand that if they use alternative wage survey, initially they have to spend extra few $100 basically, like $200-300 more than actually what they pay for attorney fees and everything basically. I think that is even worth spending that money instead of paying $30,000 more in the salary for the employee.
Got it. So, in your experience, have you seen any RFEs with respect to alternate wage surveys that anybody used in the past?
No. Not really. Maybe one or two sometimes. You see, there is always an anomaly. We may get one or two RFEs basically, and possibly some people may try to put that factor basically if people are using it more, but they cannot deny that basically based upon that because it is them who actually said that we can actually use alternative wage survey, and that alternative wage survey is actually in accordance with the Department of Labor standards, then they do accept it.
Good information, Managar. And one related question on the same.
Mm-hmm.
Now we know that an average 45 to 50% wage increase on every geographical area with respect to OES wages, right? Mm-hmm. So if you compare with alternate wage surveys, what do you think the difference would be roughly?
I would say at least 10 to 20,000 on average. It was even before the increase also, there was a 10 to 15,000 difference on an average basically. So for example, for level 2 position in Dallas metropolitan area, for software developer was around $82,000 for us, depending upon what kind of weighted average we are taking there. Basically, there are two types of weighted averages which we can take: incumbent and combined weighted averages. Companies and all companies, there are different categories, but generally we used to take incumbent weighted averages for the all companies. In that way, it was before it was 94,000 for level 2 in Dallas metropolitan area, and the alternative wages around 81,000 to 82,000. There you're getting $12,000 to $30,000 difference in the salary per year.
So you say that alternative wage salaries are even lesser than the OES even before the rise?
Yes.
Okay. Also, do you anticipate any RFEs if someone use these alternative wage surveys salaries, and then how we can possibly define that kind of RFE?
I think we already discussed this question, Prasad Garu. Basically, I mean, I have not seen any RFEs as of now today in my 17 years of practice of immigration law. Okay. There'll be anomaly. Sometimes we may get one or two anomaly RFEs basically, but as I said, there are anomalies. They are easily be defendable because these alternative wages are well accepted by the Department of Labor. That's the reason why they certify labor condition applications with alternative wages, right?
Yeah.
Yeah, Bhanagar, this is Prashant. I have one more question. You mentioned there will be a spike in the site visit, but how is this going to impact employees who are doing work from home due to COVID?
No, nothing much. It's the same thing like what we have right now, basically, because I mean, if the LCA states the work location as an employee's home, now we define clearly in the regulation saying that if somebody works from home, it is not a third-party work site, basically. They differentiated that. That's one exception they've given in the regulations, which may work in favor of the employer, basically, in seeking the approval beyond 1 year, basically. You know, I didn't go through with clarity in that aspect, but I'm going to go through that in clarity. I'm going to explain more if you're given an opportunity on that. But that's what it is going to be, basically. So if the employer works at the third-party client side, obviously they have to comply with the LCA posting at their home. They have to post the LCA for 10 business days on or before he commencing the job on the particular position, basically. And then he has to document that he actually posted. Their employer has to document that they posted the LCA, in fact, at the employee's home location, basically. And if the officer visits their house, they have to let them visit and answer the questions to them.
Sure. Thank you. Also, one more question. The premium processing fee, do you have, when is that hike going to be effective from?
So the Congress has given, Congress has given them, and when the bill has passed, basically, they've given USCIS 180 days to come up with the regulation and the policy how they're going to implement this premium processing fees, because they've not given a fixed pricing for each and every case. They've given a weighted pricing, that means scale from $1,500 to $2,500 basically for type of case and everything. That is, the USA is responsible to define what is the premium processing fee they're going to collect basically for each and every type of case and why it is. And also, the Congress said that these cases can be adjudicated anytime between 15 to 35 days basically. So they have to prescribe also which case they're going to adjudicate in 15 days, which case they're going to adjudicate in 35 days, and what is the justification for that. They have to provide all those things. So I'm expecting we don't see any action at least for 7 to 8 weeks, because that is also I'm expecting within 7 to 8 weeks, because this bill was passed actually to provide a financial support to the USCIS basically, so that they don't have to incur any layoffs in the USCIS. As we all know that USCIS survives with the filing fees what the applicants and the petitioners file to seek an immigration benefit in this country basically, So that's why I'm expecting there'll be more action, more faster action than 180 days by the USCIS. But my anticipation will be at least will be in December or January. I could be wrong, but that's what I anticipate. I can be wrong also. Any other questions, sir?
Hello, Prasad Garu, do you have any other questions to ask?
Well,
sir, your voice is not coming. Prasad Garu, I can't hear you. Your voice is not coming. I think you're muted.
how about now?
Yeah, I can hear now, sir.
One question from audience. Someone is asking, what will be my wage level salary with alternate wage survey in San Francisco? I think that's something that readily not available, and they have to take a survey by paying, correct?
Yes, sir. They have to take a survey by paying, and we have to look into it basically, and then we have to tell. And average wages will be around $120,000 to $125,000 in San Francisco Bay Area.
Thank you. And one other question. With respect to EB2 to EB3 and the recent movements in the green card side, is there any impact on either side based on this specialty occupation and the recent changes?
No, not on the green card. Specialty occupation definition is only applicable to H-1B and E3 visas, not to anybody else.
Okay. The next question is, with respect to extensions beyond 6 years, will this impact extensions beyond 6 years for renewals or extensions?
No, sir. It won't impact because the extensions beyond 6 years is dependent upon the AC-21 Act, which is a law passed by the Congress. Section 106A and B and Section 104C actually provides you to seek extensions beyond 6 years for H-1B visas of AC-21 Act. Okay. And if your priority dates are not current, that means your final action dates are not current, then your I-140 is approved, then you're eligible to apply and seek extensions as long as your priority date becomes current on H-1B visa, irrespective with the EB2, EB3, or with the special definition, whatever those regulations are basically. Same thing with the 365-day rule requirement also. Pending requirement also for I-140 or labor certification, depending on what case it is, to seek a 7th-year extension, basically.
I think the related question was, do they need a LCA or not for beyond 6 years extension?
LCA is required for every case.
Right. In that case, the new wages won't kick in if it is a beyond 6 years extension. And
it will kick in. Any new application you file, any new petition you file, whether it's an extension, whether it's a transfer, whether it's a change of status, whether it's an amendment, whether it's an extension beyond 6 years, it does not matter. The labor condition application wages will be determined pursuant to the new wage survey that came into effect from October 8th, 2020.
Okay. Another question with respect to LCAs that have been filed and certified prior to February or prior to the recent change, can they be used next year for the cap or any future filings?
If they're valid, yes. If they're valid.
Okay. And do you have any idea on what the specialty occupation restrictions that is coming forward?
I just discussed in length about that. Again, it's going to take again the whole set of conversation on that basically. And I don't know whether the audience is listening to us or not who posed this question.
Yeah, thank you, Banu Garu. I mean, you have given a wonderful summary on this, and there are a lot of takeaway messages we reiterated. We don't want you to repeat and take away your valuable time.
Thank you, sir.
Yeah, and on behalf of NATS, and thank you for moderating this. But on behalf of NATS, Banu Garu, I want to specially thank you for educating our entire community.
Sir. It's my honor. It's my honor.
Yeah. Also, I want to, if it's okay for you, I want to leave your website to our audience. So in case if they have specific questions, they can reach out to you. It's ilindralawgroup.net, Banu Babu Ilindra. So please feel free to reach out to him if you have any specific cases. With this, I want to thank once again to entire NATS team, senior leadership, and also the Tampa Bay chapter for organizing this event. And with this, officially, I would like to conclude this meeting. And finally, I want to say, if you guys come across any, if you need any help, please feel free to reach out to us at 1-888-4 Telugu. And lastly, thank you very much, Banu Garu, once again. Thank you.
Thank you. Thank you all. And please stay safe and kindly wear mask if you can, social distance. And please take care of you all. God bless you all. And thank you very much, NATS, for giving me this opportunity. Thanks, Prashant Garu. Thanks, Prasad Garu. Thanks, everybody in the NATS leadership team for giving this opportunity and conducting this timely webinar, especially for our community. Thank you all. Have a wonderful day. Bye.
Thank you. Yeah.